This is case number 22182520. This is Coolidge Imaging LLC versus City of Detroit. The matter is before the court set on for, I believe, a review hearing on today's date. Actually, it looks like a first hearing. Your appearance for Coolidge Imaging, please.
Good morning, Your Honor. Ryan Jernigan on behalf of the plaintiff.
All right, thank you, Mr. Jernigan. Your P number, if you will, for the record, sir.
P number 83482.
All right, thank you. Good morning to you, sir. For the City of Detroit, your appearance at this time, please. For the city, do I have Ms. Cobbs? Anyone from the city on this matter? So, Mr. Jernigan, the city is usually here, usually appearing on these matters. Have you spoken with anybody from the city? I do see that they have filed their answer in this matter.
Not this morning, Your Honor. Last week I did send a demand to the attorney from the city.
All right, gotcha. I think Mr. Hildner is here. Let's see, sir.
Yeah, good morning, Your Honor. Philip Hildner. I represent the city of Detroit. I'm here on another matter. I don't believe I'm assigned this Coolidge Imaging case, but if you said Ms. Cobbs is assigned to the case, I can certainly try to get in touch with her quickly and
I think
get her here or cover it.
the attorney that I was speaking to, I think, was Christopher Michaels, I think might be assigned to it.
Okay. If I can, yeah, just get a couple minutes to check in with him and see if what's going on.
What I'm seeing on the pleadings is Michael Alton.
I believe Michael Alton was initially handling the case, and I think he told me it got transferred to Christopher Michaels recently, and that's when I spoke with him last week.
And that would.
All right, thank you, Mr. Jernigan. And Mr. Hildner, if you will, see if you could reach out to that person. We'll take a moment, Mr. Jernigan. We'll come right back to you, sir.
Okay, thank you, Your Honor.
The court now calls case number 21-171768. This is Auto Club Group versus Deandra Fields. The matter is before the court set on for a pretrial hearing. The matter was last in front of me, it seems, on the looks like, well, it might have been on the 17th of May. In any event, the court did set it up so that an answer might be filed, and then I set the matter on for pretrial on today's date. Your appearance for Auto Club, please.
Good morning, Your Honor. Denise Baker, P53670 on behalf of plaintiff.
All right, thank you. And good morning to you, Ms. Baker. I am looking for Deandra Fields now. If you're on the Zoom, please say something at this time.
Hi, Your Honor. I'm right here.
All right. What is your name, ma'am?
Deandra Fields.
All right, thank you, Ms. Fields. Good morning to you, ma'am. All right, Madam Counsel, I see that there, what I received something which says Deandra Fields not guilty, Deandra Hicks not guilty, and something along those lines. So update me, if you will, Madam Counsel.
Your Honor, we were here on this matter on May 17th. There are 3 defendants to this cause of action. And at that hearing, you did order the defendants to file a proper answer by June 7th. We had personally served each of the 3 defendants, and default entry against all 3 defendants was signed but then set aside. The defendants, to the best of my knowledge, have not filed proper answers to the complaint. So we would request the default entries be reinstated.
Yeah, I'm looking through the files, through the various components of the file to see whether I see any proper answers that's been filed. Ms. Fields, did you file some answer in regard to this case?
Your court attorney, when we had called, she said that nobody really knows how to like do that answer stuff. So she said to just write a detailed letter, like saying exactly what happened, like in the order of events and give it to you and to the lawyer.
All right. I don't have anything like that in this file. Did you file something along those lines?
Yep, we did. It was before you told me I had to do it before June 7th, and we went down to there and she said she was gonna send it to you. It was a handwritten statement.
They wrote on there. He said, you see, they can't roll.
Now, the only thing that I have is a document from March the 7th that says not guilty. Are you saying something other than that was filed?
Yes, she stamped it and everything. She printed it off and stuff.
That's it right there, Judge.
Yes.
Yes. They wrote off, I'm not guilty. June the 7th, I think, yeah.
This is March.
Oh, that's March.
No, there was something recent.
All right, just one moment.
Sorry.
Madam Counsel, did you receive anything in mail or regarding this matter?
We have not, Your Honor.
All right, I see a document dated the 1st of June, and I'm taking a look at it now. All right. Well, it's really not it's really not a proper answer, and the responsibility is to file an answer consistent with the court rules. So, but what I'm going to do is I'm going to reset the hearing for a week from now, and I'm going to email to counsel the answer that was the document that was found as an answer filed with the court, because you haven't received a copy of that. So if you will chat me your email address, counsel, I will get that off to you, and then I'll bring this back next week so I can get your thoughts about this and then make a decision as to whether or not these can be applied as an answer. So if you will.
You want that to go to you directly or to the court reporter?
Go ahead and chat it here in this chat.
Okay.
The court reporter, I should say the clerk, I'll make sure the clerk gets that information so that a copy of the answer can be sent off to you. We could come back on this.
Well, next week you have a trial and you have like 2 cases, like 11 cases on a Thursday, Wednesday and Thursday.
I need to slip it in.
Well, you can do it Tuesday.
All right, so let's do it next Tuesday. It's a tough day, but we're gonna stick it in there.
No, yeah, because really the 2 next days is Wednesday and Thursday, the tough days. Tuesday is fine.
Okay, so next Tuesday, what's that date again?
The 5th. The 5th, yeah.
On the 5th. So July the 5th is when the parties will need to be back on this matter. July the 5th, and that's going to be at 10 o'clock a.m. July the 5th at 10 o'clock a.m. And I'll address the petition for entry of default and default judgment. I'll also address the request for the answer to be allowed. Madam Counsel, we're going to email that answer to you just to make sure, because it should have been sent to you by mail with a proof of service. That was not done. But we're gonna send it so that your office can take a look at it and be ready on next Tuesday.
All right,
All right,
next
so-
Tuesday at 10 a.m. Thank you so much.
So
Your
just
Honor.
make sure, you're back at that time. All right, do I have,
Your Honor,
well, 1 second, ma'am. Do I have anyone else on the Zoom that's a part of this case? Anyone else?
my mom would like to, she's on the case too. Dina Lucas.
Yeah, that's what, can you just let me ask that question?
Hi, good morning, Your Honor. I'm Dina Lucas. I'm Deandra's mother. I'm also one of the things on the case. When you said the proper answer form, now when I looked on the forms and on the website, it just says paragraph 1, do you or disagree, agree, disagree, or whatever. But I don't know what paragraphs they're talking about.
That's what a proper answer is. And when the complaint was filed against you, the complaint that was filed against you has paragraphs 1 through 23.
We
never
never
got
got anything like that. That's why I kept asking the court reporter, because I don't have anything like that. All I got was the beginning was when the case, it's a judgment against her, and when the case was. We did not receive anything like that, because that's why we did it like we did.
All right, well, I have a proof of service indicating that the documents were served on December the 27th, 2021. And that proof of service is as relates to Cedric Fields. I also have it as it relates to Deandra Fields and also Deanna Lucas. That was back in 2021, December of 2021.
Is there any way that you can email me that and I can see it?
Because apparently they did not send that. to
I
us.
don't have anything like that.
We've got, there's proof of service from a long time ago, but you certainly can get a copy of that document. So Madam Counsel, if you will, yes, Madam Counsel, if you will, I'm going to put you and the other side in a breakout room just so that you could get some information as to how you might email them a copy of the complaint. Now, there are proof of services in the file that says that those things items were served back in December by a process server.
All right.
But I'm going to put you in a breakout room to exchange that information.
Okay, I appreciate it. Thank you so much, Your Honor.
Your Honor, the proofs of service also contain a description of all 3 parties. The summons and complaint were served on each of them on that date.
Right, that's exactly what I just indicated. But again, I'm going to ask that you send a copy by way of email so that we're on the same page at the next hearing. And I'm sending you to breakout room 1 to exchange the proper information so that you can do that.
Yes, Your Honor.
Thank you, Your Honor.
Yeah.
Sure.
We're back on the record regarding the Coolidge Imaging versus City of Detroit. I see that Mr. Jernigan is there. Mr. Hilton, were you able to find out, strike that up, your appearance for defendant with regard to Imaging versus City of Detroit? Mr. Jernigan has previously entered his appearance. Your appearance, counsel.
Good morning again, Your Honor. Ryan Jernigan for the plaintiff.
I got you, Mr. Jernigan.
Oh, okay.
I thought Mr. Michaels is there. I'm waiting on the city.
Yes, Your Honor. Chris Michaels on behalf of the city. I apologize. We're running a little late today. I am here on behalf of the city in this matter.
Your P number, if you will, Mr. Michaels.
Oh, it's P83156.
All right, thank you, sir. And again, good morning to you. I see that the matter has certainly been joined here, and I also heard that Mr. Jernigan sent over a demand. Kind of want to know where things are. Certainly, the court can set up a schedule on this case. But if you're moving towards a possible resolution, then I'd like to manage it in that way. Your thoughts, Mr. Mathis, given that there has been, Mr. Michaels, I'm sorry, given that there has been a demand made in this matter.
Your Honor, we would like some discovery. There is I believe, a case in circuit court for the underlying claimant. If they could move it into that, so if there would be a settlement, it could be a global settlement. That would be preferred. And I can't force him to do that, but it would. I know that I received this case about a month ago from the previous attorney, so I've been handling mostly with the underlying claimant. I do see there has been a demand made, but at this point we would need some discovery. If I don't think settlement at this exact moment is in the ballpark.
All right, thank you, Mr. Jernigan. Your thoughts on this matter?
We're not interested in joining the main case, but you know, they're entitled to discovery. Hopefully we'll be able to settle down the line, but I don't have a problem cooperating in discovery.
All right, gotcha. All right, real good. I will set it up. I will allow 60 days discovery, and actually it might be a little bit beyond it because discovery will be open through the next hearing date, and that next hearing date is going to be
September the, yeah, those two jury trials. The 5th or the 12th.
the 5th. That's
I'm sorry, the 6th. Sorry.
yeah, we're
Yeah.
all right. All right, 9/6/21 will be the next 22. 9/6/22 at 9:30 a.m. will be the next action date on this matter. That date will be treated as a pretrial date, and discovery is extended through that period of time. Now, the court also is setting that date as a date for motion hearings to the extent that you wish to bring a motion. If you do not bring a motion for hearing by that date, that does not preclude the court setting a future time. But here's how it works as it relates to the 6th of September. It will be treated as a pretrial date. You can bring a motion and the court will hear your motion on that date, so long as you file your motion early enough to give the other side at least 10 days to respond to your motion. So notwithstanding the court rules in this regard, the court shortens the time if necessary, so long as you file a motion dispositive or otherwise and set that motion for hearing on the 6th of September, and make sure that you give the other side at least 10 days to respond to your motion. I will hear it on the 6th of September. So you'll receive a scheduling order from me. It will contain the language that I just indicated. It will also have the new court date. It will have the discovery cutoff time. I'm not setting any exchange of witness lists and things along those lines at this time. I'll review all of those matters at the next action. Right. Anything further at this time, gentlemen?
No, Your Honor.
No, Your Honor. Thank you.
You'll get that scheduling order from me in the mail in the next few days, or good day to you.
Thank you, Your
Thank you, Your
Honor.
Honor.
All right, we're on the record regarding case number 22-177-199. This is Healthcare Imaging Partners versus City of Detroit. The matter is before the court, set on for a pretrial conference on today's date. Your appearance for Healthcare Imaging, please.
Morning, Your Honor. Andrew Bush appearing on behalf of the plaintiff.
Thank you, Mr. Bush. And your P number, if you will, for the record, sir.
Yes, sir. P84194.
All right, thank you, sir. For defendant City of Detroit, your appearance, sir.
Good morning, Your Honor. Philip Hiltner, P77913, for defendant.
Thank you, Mr. Hiltner. And again, good morning to you. I see that there is a motion for a change of venue filed in this matter. And it looked like the timestamp got it wrong, because it indicates that it was submitted July the 16th of 2022. Last time I checked, we haven't got there yet. So tell me about that. And I also see a motion to compel discovery. So somebody update me, what's going on here?
Your Honor, I filed the motion to compel, but I've since received discovery responses, so that's I can withdraw that motion at this time. I'm not familiar with the motion for change of venue. I saw that on the Register of Actions this morning, but I didn't file it as far as I know, and I don't have a copy.
And yes, Your Honor, just kind of following up on that, plaintiff didn't file that motion, I don't believe either, so not sure if that was a mistake.
I see what has happened here, because it's got Mr. Hilton's name all over it, so we could plaster him to the wall with it, but the problem is that on the notice of hearing has motion for change of venue, but the motion itself is a motion to compel discovery. So therein lies the problem. So Mr. Hilton saved by the bell. Right.
All right.
All right. So I take it then that I've already issued a scheduling order with respect to discovery in this matter?
Yes, Your Honor, as I understood it, today was the deadline for motions and discovery.
And for some reason, all right, let me see what's going on here. I don't see my scheduling order in the file. So discovery is complete then, right?
From defendant's perspective, yes, Your Honor.
Yes, Your Honor, we just exchanged that recent discovery and I believe we should be all set, work towards a resolution.
All right, very well. So how much time do you need, or you want to go to a breakout room and talk about this today? Want me to come in there with you, or what do you need?
Maybe just a little time, Your Honor, maybe just 30 days.
All right, because I did wear my make it work out today tie. I'm being facetious. All right. So I'll send it over for review, if you will, in the next 30 days. And of course, if you've not been able to get to a resolution, we can look at setting it up for some type of trial situation. But given that there are likely to be some discussions, I'll go ahead and adjourn it over 30 days. Make sense to you, Mr. Hilder, as well?
Yes, Your Honor.
All right. So
August 2nd.
August 2nd, 8/2 is going to be the next action date on this matter. And I'll set that up with 9:45 a.m., 8/2, 9:45 a.m. And it's styled as a pretrial review. Thank you, gentlemen. I'll see you real soon. Good day to you.
Thank you, Your Honor. Take care.
Thanks, Judge. Have a good one.
The court now calls case number 22-177500. This is iHealth Pharmacy versus City of Detroit. The matter is before the court, set on for pretrial conference. For iHealth, your appearance at this time, please.
Good morning, Your Honor. Jonathan Green on behalf of the plaintiff. My P number is 51461.
All right, thank you, Mr. Green. Good morning to you, sir. I'm looking for the other side on this for the City of Detroit. Your appearance at this time.
Your Honor, I just sent an email a few minutes ago to Joel Ashton, who is the attorney for the city. I told him, I reminded him we have this thing this morning. I also have the MAIPF as a defendant with Cinnamon Planca. Your Honor, this isn't a terribly large case. Maybe the thing to do is, since they're not here, can we adjourn it like 30 days and I'll get on the horn with both of them and see if I can just wrap this up.
All right. All right. Sounds reasonable to me, counsel. So I'll go ahead and set it up in that manner. So we'll have you come back on the 2nd of August, and I'll go ahead and set that for 9:45 as well. So you'll be right in there at 9:45, 10 a.m. When I'm hearing. But 9:45 will be the set time on this.
Thank you, Your Honor. I'll make sure everybody knows.
Thank you, sir. All the best.
All right. Take care, everyone.
So the court now calls case number 21-167-456. This is Midland Funding LLC versus Danielle Brown. The matter is before the court, set on today for a pretrial conference. Your appearance at this time, counsel.
Good morning, Your Honor. Navjot Francis, P72322 on behalf of Plaintiff's Attorney of Record.
Thank you, Ms. Francis. Good morning to you. I'm looking for Ms. Danielle Brown. If you're on the Zoom, say something at this time, please.
Yes, I am here.
All right, good morning to you, Ms. Brown.
Good morning.
So I know I set this up and granted 60 days of discovery, and then I would bring this matter back for this particular hearing at this time. Update me, if you will, Madam Council.
Your Honor, we did file a motion for summary disposition, which is also, I believe, scheduled for today. So we are ready to proceed on that motion.
All right, and I have your request for admission, interrogatories, et cetera. I have the, even where you filed a witness list. What I do not have is your motion for summary disposition. Ms. Brown, did you in fact receive the motion for summary disposition in this case, ma'am?
I don't know what that is. What I did receive was a packet of papers that basically had like the contract agreements and purchases and things of that matter. And I don't know if I need to clarify this. I'm not denying that this is what, responsibility. I'm not doing that. So I don't know where that came from.
Right. I understand it, ma'am. There was another document, and I have found it now. I found it that something that I had set aside from earlier, and that is the motion that was filed, and that's a motion for summary disposition in this matter, and it really addresses the fact that there doesn't appear to be a dispute regarding the obligation in this case. It also addresses that there was certain requests for interrogatories of production of documents that were not received, and at the time to answer those had already passed. Did you receive a copy of that document, ma'am? It was sent to you? It was a rather thick document, and it's called a motion with summary disposition.
So if it was included in that paper, I mean, I did get a really thick stack of papers. When I flipped through it, from my knowledge, it just was the information. I didn't see that there was something that I needed to fill out or return.
All right, then. All right. So what's your dispute in this matter, Ms. Brown? What do you want me to know? Because
I just need to get on a reasonable payment plan. That's really all I'm asking for. That's really it.
all right. So it sounds like the court would enter the judgment in this matter, and you could certainly petition for a payment plan. But have you, Ms. Francis, have you talked to Ms. Brown about whether or not there can be an agreement regarding what a payment plan might look like in this case?
I have not, Your Honor. I would be happy to.
Yeah, I'm gonna send you to breakout room and talk about that, understanding that the court's gonna enter a judgment or agreement, a document that says that you owe a certain amount of money. And if you can reach an agreement on how to pay it back, that's good. If not, you can always petition the court to set an amount. And if that amount is reasonable, the court will likely grant that petition. The first step is to see if we can work out an agreement between parties and then get on the payment plan and start forward. So I'm gonna give you a chance to talk with each other about that for a moment, and then you can come back into the courtroom. So Ms. Brown, I'm sending you a notification for breakout room 2, and Ms. Francis, I'm doing likewise. And I'll see you in just a few moments. Is the motion for some. Cases,
Oh, that's it.
welcome back regarding this matter. Ms. Francis, if you'll update me, please.
Thank you, Judge. We did come to a payment agreement. Defendant will pay $100 a month beginning August 1st and by the 1st of each month thereafter until the judgment is paid in full.
All right. So I will enter the judgment upon presentment, and that judgment will contain language that allows for the payment at $100 a month commencing in August.
I'm sorry, I have a question. Can those payments be put at the end of the month? Because the beginning of the month is very tough for me. And I can even make that payment today if I need to start it at the end of each month.
Got it. So you were gonna start at August the 1st. We could actually, I mean, whichever way you want to do it, we could actually put it at the 29th of July. And that would give you the end of the month, and then it would be due that last Friday of each month.
Okay, that's better for me.
That makes sense? Okay.
Yes.
Ms. Francis, you got that, Ms. Francis?
You said July 29th?
Yes, ma'am.
Okay. And Judge, would you like us to submit the judgment as a summary disposition judgment or as consent judgment?
Yeah, go ahead and submit it as a judgment granted by summary disposition, but include the payment terms in that judgment. And that the payment terms are by way of agreement.
Thank you,
And get
Judge.
that over to me, and I'll sign it, and we'll make sure Ms. Brown gets a copy as well.
Thank you, Judge.
All right, thank you. Thank you, Ms. Brown. Good
Thank-
day to you.
Thank you. You too.